Hello, Court Master.
ಹಲೋ ಹೇಳ್ರಿ ಸರ್.
ಹಲೋ ಮೇಡಮ್.
ಹೇಳ್ರಿ ಸರ್.
ಮೇಡಮ್ ಎಷ್ಟೊತ್ತಿಗೆ ಕೋರ್ಟ್ ಸಿಟ್ಟಿಂಗ್ ಚಾಲು ಆಗೋದು?
11:30 ಸರ್.
ಓಕೆ 11:30ಗೆ ನಾವು ಲಾಗಿನ್ ಆದ್ರೆ ನಡೀತದಲ್ಲ?
ನಡೀತದೆ ಸರ್.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು ಮ್ಯಾಮ್. ಥ್ಯಾಂಕ್ಸ್.
Your Lordships, so one matter for end of the list, Your Lordships.
What is urgency?
It is a no confidence motion matter, Your Lordships. Election is scheduled tomorrow, Your Lordships.
Inform the state.
Yes, we have served the
Yes,
copy
ma'am.
also.
Yes, ma'am.
Put it.
Make it fresh matter. Fresh writ appeal tomorrow, notes.
Urgency?
Yes. Regarding election to the post of mayor and deputy mayor.
Hmm.
Notes, against that notes, this appeal is filed. They have ceased to be the corporators. Despite of that notes, learned single judge has permitted to conduct the election, which is impermissible.
One matter.
Server in advance
Sir,
to the concern.
yes,
A matter for Friday writ appeal, my lord. The learned single judge has passed an order to conduct an inquiry against the officials and file a report by 11th February. So there is urgency, my lord. We are seeking for stay of the order of the learned single judge. It may be taken up on Friday, my lord, writ appeal.
Tatkal justice.
My lords, this is a writ appeal regarding service matter for admission, my lord. I am for respondent. The honorable court has stayed the matter, my lord. Writ was allowed in our favor, my lords. And the matter has been stayed by this honorable court, my lords. So it involves urgency, my lord. Service matter, it is of appointment, my lords. He is continuing in service, my lords.
Correct, but then it has to be heard finally.
No, my lord, for admission, my lord. It is for admission.
No,
Maybe-
already- Correct. Already there's an order of stay.
Yes, ma'am.
So if it has to be disposed of,
Yes,
Then
my
by
lord. Because, my lord, he will lose the age, my lord, because criteria for retirement will be 60 years, my lords. And now he is already.
date could next.
Page wise adjournment. Page number 6, serial number 15 to 21. Page number 7.
Lord, serial number 19,
Yes,
one, my lord, kindly have it next week, my lord.
at request. We list the matter on.
Serial number 19, my lord. Yes, yes.
Next week.
Next week.
Page number 7, serial number 20. Order matter, serial number 1, Anant S. Jagirdar.
Week's time granted to do the needful. We list the matter week after next.
Number 2, Gavali Deepak K.
My lord, 1 week time may kindly be granted.
Week's
To
time
comply
granted
office objection.
to comply with the office objection. 21 matter, oh. Yes.
Later on, I appeared, no objection, no say, I appeared.
I might be there.
Sanganagowda V. Bigadar.
Week's time granted to do the needful.
Serial number 4, Patil Shantabai Subhash.
Appearing for appellant, my lord.
One nimsham.
Appear for
Real,
respondent.
just 1 minute. Really,
My lord, it's a wife,
just 1 minute. 3.6, necessary process to be furnished for issuance of notice to the unserved respondent. Respondent insurer to file acknowledgement for having deposited 50% of the award amount, 3.67. 3.7, weeks time granted to take necessary steps. And same, 3.7 only, same, to file acknowledgement for having deposited 50% of award amount. 3 point. So and so for R1. So and so for R2. And this for R2. Huh? And issue notice to the other response. 3.5, same order as 3.4.
Number 4, Patil Shantabai.
And for appellant, my lord, it's a wife's appeal, my lord. Ex parte divorce petition is granted to husband respondent. My lord. Being agreed by that, this appeal is filed. Last date of occasion, honorable court is directed to secure records. So records yet not received. So immediately after receiving records, the matter may be heard. Otherwise, if respondent no ready, I am ready. My lord.
Allah, my lord, sir. So matrimonial dispute, the husband, my lords, who is working as a software, now he is, because of all these criminal cases and other things, now he is not working last 1 year. The 2023 marriage, my lords, hardly about 2 to 3 months they stayed together. Thereafter, she deserted. Now if they are not, other side is ready, because both are educated and matured.
Yeah, that depends on both of you.
Adike, if the, that is why I am making.
It's a ex parte decree.
Correct, that is
Allah,
on-
on technicalities.
that is on merits.
Yes, my lord.
Now he's saying that they will, they're open to some.
Divorce
kind of-
petition filed by a husband, my lord. Desertion of wife is not arised.
Correct, that's on merits.
Huh.
Now they are saying that if there is any way of amicable settlement, they're ready to explore.
Appellant is ready to go with him and lead life.
That's not
but he
possible.
getting second marriage, my lord.
No, no,
That's
no.
why he's taking.
Allah, my client is
taken a
here,
day.
boss. I
Ex
inquired
parte
about all those
decree.
things. He is not getting any marriage. And now also what he has specifically stated yesterday is that few days back, my lords, he was called upon in the police station. And literally they have threatened. He is not software. Now he is not working because of all these cases. Kindly see the situation, lords. If she is at the earliest point of time, after doing all and calling upon the entire family members to the police station and threatening him, the person thereafter they are requesting to rejoin. These are not things it has to be considered. In a matrimonial dispute, they will take up lords law by utilizing the provisions in their favor. They called upon and threatened. That is what he is saying in Karnataka police station.
My lord, the complaint, I have produced a complaint also here, my lord, in appeal. After the getting divorce of decree in his hand, thereafter they thrown out the appellant. I got a decree of divorce, so you go out your home, matrimonial home, whatever you want to do. Like this is the
Now-
attitude of his.
Now it's up to you. If the matter is remanded, you are going to, it's going to take years to settle. How you are going to negotiate, it's between you. We
Then-
leave it open. That you will have to work it out. We cannot impose a settlement.
Yeah, I am not,
But
not
if
sorry.
matter, correct, if the matter gets remanded, it's going to get.
Allah,
stuck.
that is why what I am making is, my lords. If other side is, my lords, ready to.
That you have to sit and talk with them.
In
find out.
before.
They're
family
only
member-
ready to come. They are not considering any other option. So you try and sit together and see what can be done. Give a date. Reminder to be issued regarding summoning of TCR. Relist the matter on.
Acha.
Ramachandra.
Yes. Yes, government.
Five government is no. Private respondent 2 and 3, Sudarshan is affected.
Sudarshanyam.
What is the direction? Respondent number 1. Next week and ಇದು ಸರ್ lawyer ಇದೆ. ದರ್ಶನ್. Lawyer ಹೆಸರು ಕರೀರಿ. Lawyer ಹೆಸರು
Sudarshanyam.
ಪಾರ್ಟಿ ಹೆಸರು ಯಾರು ಇದ್ದಾರೆ ಪರ್ಸನ್. ಪಾರ್ಟಿ ಹೆಸರು ನೋಡಿ. ಜಿಸ್ಕಾಮ್.
Managing Director of JESCOM.
ಲಾಯರ್ ಕರ್ಕೊಂಡ್ ಬನ್ನಿ ಪಾಸ್ ಓವರ್.
Till number 6, Mahantesh Patil.
My lord. 6, it has complied, my lord.
Yes.
Complied, the difficulty is that, my lords, the name is wrongly entered. Sangha Mitra Marakunda, they have entered instead of Melkunde. Again, it will take notes. Let them, there is some observation with regard to correction of the name in the review record. Adu page number 4 RTC notes.
What was the direction now?
Direction to enter the name of this petitioner
Page?
based on the registered sale deed. The impugned the direction, my lords, is at page number 21.
Name of the petitioner.
Petitioner.
Ah,
Name of the petitioner is Sangamitra Melkunde.
ah.
They have entered Markunde.
Okay,
Again,
leave it
again we have to give a representation and it will take another mandamus and all those things. no? That is why let them correct it, no? Because the name itself they have entered wrongly.
ಅದು spelling mistake ಇದೆ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
Yes, it will be,
Huh?
my lord, it will be, kindly observe this point, it will be corrected in records of right.
We'll record that undertaking.
Yes,
The counsel for the complainant submits that the direction of the single judge has been complied with insofar as name of the complainant has been entered in column number 2.
Column number 9.
Column number 9. However, it is submitted that there is a spelling error
yes,
insofar as the name is concerned. And though the name should read as Sangamitra Melkunde, it is shown in the RTC as Sangamitra
Markunda.
Marakunda.
Son of Revanappa Markunde. Adu ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ.
Son
ಎರಡು
of
ತಪ್ಪಾಗಿ.
Revanappa Marakunda. Full stop. Lord, the AGA submits that such spelling error would be corrected.
yes,
In light of said submission, proceedings are dropped.
I may be given, my lords, liberty to furnish this copy to make corrections. ಅದೊಂದು ಕಾಪಿ ಹಚ್ಚಿ I will give the
Needless to state, petitioner to furnish necessary details to enable the authority to carry out rectification of the spelling mistake.
Kumar Amaragundappa.
my lord. 1 week time may be granted, we will make necessary entry in records of rights, ma'am.
At request of the respondent state, relist the matter on. Yes,
Number 8. Hearing the night, MIL please.
Appeal is dismissed on default, non-compliance of office objection. Now I have complied the all office objections.
you complied.
Yes, ma'am.
Yes, there is delay of 1,100
Yeah, for 1,100.
164 days, ma'am.
Why 3 years delay?
Melas the same, very same subject matter in the suit property. Melas RSA is pending. RSA is disposed now. Melas and even Melas the appellant is died. Melas, therefore I could not complain while.
So we'll recall. You have complied with all the
Yes,
office.
but after complaints, Melas the appellant is also expired. Melas died. Melas
And then you file whatever necessary application.
I will file.
I'll adjourn it,
Please,
you file.
1 week time.
Counsel for the appellant submits that the appellant has passed away. In light of such development, appellant necessary steps to be taken as regards the deceased appellant. Relist the matter.
Please, Macho.
Number 9. Prashant B. Adjournment.
IA may be allowed. IA may be allowed, date may be fixed, ma'am.
My lord, not issues, my lord, this matter, my lord, already court has heard, my lord. The court has given this HF Sangati versus registered adon judgment ನೋಡಿ ಹೇಳಂತಂದಿದ್ರು, my lord.
Correct?
Yes, my lord.
We are sitting in a different combination.
Yes, my lord.
It has to come before the same bench if it has been heard.
Yes, my lord.
So we'll fix a date next week, let it come.
Short it, my lord, there is no
Correct.
still.
This week.
Please, please, my lord.
Same bench is on.
Please, please.
Deal is the matter and same stage on.
Number 10, Ravi.
Date. Date,
Well,
please.
Steve, Shravan,
My lord, along with appeal, appellant has filed the condonation delay application, my lord.
Notice must go.
Yes, my lord.
Issue note, IA 1/25. Why are you seeking dispensation of A to D?
They are the Xerox copy of documents in writ petition, my lord. We will produce after next hearing, we will produce, my lord.
No,
And
you are
in
relying
writ
on it or
petition,
not?
in writ petition, we filed a copy of those documents, my lord.
Correct. So why are you seeking dispensation? Are you saying you are not relying on it or you undertake to?
No, no,
furnish it?
we are not relying on it. We are relying only on annexure E, my lord, that is certified copy.
Correct, but this you undertake, we will give you time. By the time notice is served,
Yes, ma'am.
you undertake to file A to D.
Yes, ma'am.
1/25 is disposed of, granting 2 weeks time. 2 weeks time
Yes, ma'am.
to the appellant to furnish the copies of annexure A to D.
Notice may be issued.
Issue notice on IA as well as main. Anybody appeared?
No, my lord.
No, in the, before the single judge,
Yes, ma'am.
the appellant is also at liberty to serve counsel who appeared in the writ proceedings.
Obliged. ma'am.
Kumar,
Your lordship, there is a delay of 94 days in filing this appeal. Your
Take out notice.
Much of,
So notice on IA as well as main.
much of,
PCR to be summoned.
much.
but Chaitanya,
You know, the NCR has not yet received. ma'am. On the last date of hearing, your lordship directed to my lord call for records. Kindly have this matter Tuesday, my lord.
File your objection.
Yes, meantime.
A reminder to be issued regarding TCR summoned. Reminder to be issued telephonically. In the meanwhile, objections to be filed, if any, to be filed on IA 1/24.
Please.
Relist the matter.
30, Kedar Desai,
The matter. Relist the matter.
Obliged.
14,
Is it enhancement?
For respondent.
Enhancement,
Probably, my lord, copy not yet been served by other side, my lord. Please,
copies of the appeal memo to be served on the other side.
please. Obliged.
Prepare for petition, man. Delay, my lord. Notice may be, lord.
Issue notice on IA as well as main. PCR to be summoned forthwith.
Obliged.
number 15, Amir Hamas, Abdul Qadir,
Kindly pass over.
ಏನು
ಪಕ್ಕದಲ್ಲಿ ಹಿಯರಿಂಗ್ ಇದೆ ಸರ್. ಪಕ್ಕದಲ್ಲಿ ಹಿಯರಿಂಗ್ ಇದೆ, ಪಾಸ್ ಓವರ್ ಮಾಡಬೇಕು.
ಅಲ್ಲ ಆಯ್ತು, ಬಟ್ ಫುಲ್ ಹಿಯರಿಂಗ್ ಆಗ್ಬೇಕು ಅಂದ್ರೆ ಟೆಸ್ಟ್ ಬಿ ಬಿಫೋರ್ ದ ರೆಗ್ಯುಲರ್ ಬೆಂಚ್. Have it next week.
ಎಸ್ ಸರ್.
We'll list the matter on. What is this transfer matter?
ಟ್ರಾನ್ಸ್ಫರ್ ಮ್ಯಾಟರ್.
Ah,
ಪ್ರೀ ಮ್ಯಾಚ್ ಟ್ರಾನ್ಸ್ಫರ್.
huh?
ಪ್ರೀ ಮ್ಯಾಚ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮ್ಯಾಟರ್.
Last week it had come.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ನಾಗ ನಾನು ಇದು ಮಾಡ್ತೇನೆ ನೋಡಿ ಸರ್.
Huh?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ನಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ತೀನಿ ಸರ್.
No, but now you have already uh, reported at another place, isn't it?
Yes, sir.
And then
Mudgal.
what remains now?
ಈ 2 ತಿಂಗಳಾಯ್ತು ಸರ್ ರಿಪೋರ್ಟ್ ಮಾಡಿ
ಹಾ.
ಪ್ರೀಮ್ಯಾಚರ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿತ್ತು ಬಟ್ ಈಗ ನಾವು ಅನ್ನೋದೇನು ರೈಟ್ ಅಲ್ಲ ಇದು ಟ್ರಾನ್ಸ್ಫರ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದು ರೈಟ್ ಅಲ್ಲ ಅಂತ.
No, but you are working now in terms of the order of transfer. Huh?
Yes, sir.
Now,
Then
KAT
after it is modified by the order of the KAT.
on the ground that it was a premature transfer.
Premature transfer.
Now, how can you show it was not premature? Court has given a finding.
On administrative ground ಮೇಲೆ ಮಾಡಿದ್ದಿತ್ತು ಸರ್.
I'm sorry, but unless the procedure for premature transfer is adhered to, which and the transfer guidelines of statutory force, tenure is 4 years. It was done without following the procedure.
Yes, sir.
There ends the matter. What other ground we can take? Government has not challenged it. Government is the employer.
Employer.
Now you are already working at the place where you are transferred to. There is no case made out.
Okay.
Huh?
I will do that, sir.
Sombara, whatever
sir.
you want to say.
Sir.
Release the matter on Monday. Two months he is working there. Yes.
Okay.
I appear for the complaint, my lord. But the order which was
What is the
passed,
direction?
my lord, in page 19, my lord, the respondent number 2 is directed to pay the substance allowances, my lord, from the date of 24/2011 to 29/2014, my lord. They have not complied the order of.
You are still under suspension, is it?
No, the suspension was
Revoked.
revoked.
Now, who is respondent number 2, society?
Yes, ma'am.
Emergent notice to R1. KGA is directed to accept notice for the pro forma respondent. Release the matter.
Obliged.
70, which is Kanachari.
Applying for the complainant, lordship. Being aggrieved by not obeying the interim orders of the single bench, your lordship. The facts of the case is that there will be issuance of a recruitment notification to the post of assistant professors at University of Agriculture Science, Raichur. I will apply to the said post, your lordship, wherein the university rejects my candidature on a certain grounds, against which I approached to this honorable court. And this court passed an interim order directing the respondent number 2 herein, that is accused number 2 herein, to permit the complainant to participate in the recruitment process. Later on, your lordship, on 20, after that, as per annexure C, your lordship.
So they did not allow you to participate.
Yes. What they did, your lordship, as per annexure C, they modified as per the interim orders regarding my eligibility, and they allowed me.
Page?
Page, your lordship, 41. As per the interim orders of the court, they updated the notification. Wherein, this is regarding the conducting of the examinations, your lordship. In this one, this examinations is with respect to the 3 recruitment notifications in which I have applied to the, in page number 42, your lordship, reference 1.
No, no, in page 41.
Yes.
They modified it and treated you as eligible.
Yes.
Then
This
what?
is as per the interim orders. After that, page number 42, your lordship, annexure D. In that one, your lordship, reference 1, this office recruitment notification number so-and-so dated 18/10/2023. Against this, your lordship, they issue a notification for the written examinations to be conducted, along with the hall tickets they will issue. In this one, page number relevant, page 44. In that, your lordship, for all the subjects, they will call for the written examinations, excluding my subject. My subject has been omitted. That is the assistant professor to the post of agricultural marketing. And for there is no any reason assigned, your lordship, for the omission of this subject.
Correct, but that you have to separately challenge. Now, suppose they want to abandon the recruitment for a certain post They can do it.
But your lordship, there is an interim order passed by this court permitting me to participate in the process, but
Okay.
they have willfully, they have omitted my subject, only my subject, your lordship. I am the only applicant to that post.
Who's the authority?
Your lordship, University of Agriculture Sciences, Raichur. Respondent number 2, your lordship, registrar.
3.
Yes,
Respondent number?
2, your lordship.
Notice.
Your lordship, one submission.
Uh,
Only after filing of this writ contempt petition, yesterday the registrar calls to the candidate and he informs that we will update the website regarding the conducting of the examination to my post. We will update it regarding the website by evening and we will dispatch the hall ticket.
Then let
Wherein, yes, your lordship, I will submit a memo regarding that copies.
correct. So then now either it is settled amongst yourselves and they modify it.
Yes. Yesterday they have updated in the website, your lordship, wherein the notification which has been updated is of the date 31/1/2025. That notification regarding the written examinations that has been published on 27/1/2025. Now, my notification, my allowing me to participate in the written examinations, that has been published on 4/1/25. That is just only yesterday after filing of this contempt petition, your lordship. So this means that there is a willful disobedience and a negligence towards the orders.
Forget about that. Now, if your interest is being served.
Yes.
And they're going to allow you to participate in the recruitment process.
Yes.
It's better you take advantage of the opportunity.
Yes.
We'll simply adjourn it.
Yes.
You find out.
Yes.
If they allow you to write the written exam, leave it.
Yes.
Because if you were to issue notice, it will unnecessarily cause bad blood between you and them.
Okay.
Interview time, even if you do very well, they will give you 0.
Yes, that is there.
So we leave it at this, sir.
Okay.
I'll just adjourn it next week.
Yes.
If they allow you to write written exam, you can simply withdraw it.
Yes.
And take your chance.
Okay.
Relist the matter. I'll have it the week after next.
Yes, sir.
Week after next.
Your lordship, the exams are conducted from 23rd. It might be
23rd.
taken after that.
Relist the matter in the first week of March.
Yes. Obviously.
For the respondent number 2. This is
This requires hearing regular bench.
requires, because we have challenged the order of the learned single judge in regard to claim of a promotion even during the period of DPC. Inquiry was pending, my lord, the claim was made, my lord, writ petition has been allowed. In view of Janika Raman's case, my lord, once, not after inquiry, punishment has been imposed. But during the inquiry, there was a DPC, his promotion was kept in seal cover. Lord, when inquiry was concluded and order was passed imposing punishment of censure, Lord, his promotion was considered only after completion of the inquiry, after passing of the punishment order. But that has been challenged, claiming that he should have been granted even during the pendency of the inquiry. Because the DPC was already sitting and my promotion was kept in sealed cover.
As on the date of the DPC, there was no charges framed.
It was pending, Lord. Inquiry was pending. For that reason, Lord, DPC kept the promotion in sealed cover till completion of the inquiry.
If it requires hearing, we'll have it next week.
May I submit, my lord?
So we are saying that if it requires hearing, we'll have
But
it
the
next
short point is whether the penalty of censure could come in the way of denying him the promotion retrospectively, my lord. That is the short point, my lord. He was two inquiries were initiated. Both ended up with a warning, censure. What is the effect of censure is the one which is to be decided.
that the employer must take its stand. Who appears for
No,
the
my lord. The
employer?
judgment of Supreme Court specifically says that it comes to an end the day and the time when it is imposed.
Yes.
Once the day and time it is imposed, my lord, it evaporates, means it is nowhere available. Therefore, my lord, I cannot be denied is the promotion, and placing reliance on division bench judgment, the large single judge has allowed the writ petition. The division bench judgment, my lord, categorically says that he would be entitled to retrospective promotion.
Yes, that Janika Raman's case, my lord, Supreme Court has held. Once order is passed, even in the case of censure, after the punishment order is passed, from that date, he will be entitled for promotion. That is the principle which has been laid down by the Supreme Court.
We'll hear it in the regular bench.
Please.
Relist the matter on
Bapu Gowda Siddhappa.
For the appellant, for claimant's appeal for seeking enhancement.
Very
First
for
one
respondent number-
is the case of injury, my lordship.
20 and 21 arising out
are
of
same accident modes. First one is injury case modes.
Yes.
The appellant was sustained the thin rim subdural hypodense fluid density of left frontal region.
No, who appears for the insurer?
I'm appearing for respondent number 2.
The tribunal was awarding the global compensation of rupees 50,000. He was indoor patient for a period of 4 days in the hospital. And the medical bills is of rupees 44,000.
What is the ground financement?
The pain and suffering is not awarded. The medical bills is around about the 44,348.
438.
Yes, 438. This is the MSC pertains to 438. Page number 24.
Para 20, the Honorable Court has discussed regarding the rejection of on the ground that they have not produced any wound certificate and prescriptions. Only medical prescriptions have been produced before the Honorable Court.
Wound certificate?
No, ma'am.
Wound certificate?
I produce the copy of the discharge summary after the wakalat notes. Yes. I produce notes.
Tribunal munde kottidira?
No. That is the reasoning.
Yes. Discharge summary notes. If he is indoor patient for a period of 4 days in the hospital.
This was not produced before
Yes,
the tribunal?
not produced before the tribunal.
Why? Yes.
They have not produced.
Alla ಈಗ ಇಲ್ಲಿದೆ. Go to Lok Adalat and.
Lok Adalat ಹೋಗಿ ಬಂದಿದೆ ನೋಡ್ರಿ.
Already submitted by the appellant counsel, my lord, that the matter was referred for Lok Adalat. There, it was not considered, my lord, because it was not marked and before the tribunal.
ಕೊಡ್ತಾ ಇದಾರಲ್ಲ. ಈಗ 4127 ಹಾಕಿರಿ.
Yes. Pardon?
Have you filed application?
I have not filed. Only that discharge application is
there.
Yes.
You are not producing it to 4127.
Yes, additional document.
It on record form.
Yes.
Yes.
If you file an application and then take it to the Lok Adalat,
They may consider it.
Yes.
You have not produced that evidence before the tribunal.
Tribunal notes.
You have directly come here.
Yes.
You have not filed an application 4127 also.
Directly I produce the copy, but
Then
yes, I'll file the application.
File it.
ಅದೇನು ಬರೀ ಜೆರಾಕ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಿ?
Original copy is in the first settle.
Right, so you file an application.
If it is filed,
No, man, they are not furnished.
originally is there, you can consider it in a local. Why?
Because, my lord,
it is a United Vijaypura company, but is there not acceptable notes?
Because they want the document to be exhibited, my lord, because they will put some questions, my lord. That's why.
ಅಲ್ಲ, ಇಲ್ಲಿ 47, 4127 ಇದೆ.
Yes, my lord. If lordship allows that petition, my lord, allows the
How can they refuse on that?
No, my lord, they will not refuse, my lord, if it is allowed, my lord, but last time.
Your officials, they are sticking on to the technicalities, right? You cannot.
Yes.
If the original material is there, the evidence is there, the certificate is there, why can't you consider it?
Even otherwise also.
You are sticking on to.
Doctor is not
Bedari. See, what he is asking is, he was 4 days.
Yes, 4 days more. 4 days.
Patient. In that regard, the adequate compensation was not given, so enhance it. That's what he is asking.
Yes.
If he was inpatient for 4 days, then obviously attendant charges to a certain amount will have to be considered. To settle that,
Yes, then matter may be referred.
maybe around another 20,000.
After the application is allowed, my lords, after additional document is allowed, may be referred.
I'll have 15 to 20,000 rupees additional amount.
He will not agree, my lord. Land council will not agree for 15-20,000 before.
25,000 was the global ones.
ಇಪ್ಪತ್ತು ಸಾವಿರ ಅದಕ್ಕೆ ಇಂಟ್ರೆಸ್ಟ್ ಸೇರಿಸ್ತೀವಿ, ಆಯ್ತು, ಮುಗಿದೋಯ್ತು. ಈಗ ಹೇಳಿದೀವಿ. Now it has been told to you.
Yes.
For you also, you work out on.
Now see,
Yes.
Offer is 25,000,
With-
global enhancement is going to round it off.
Yes.
Yes, my lord. But that application has to be allowed, my lord, because the.
It's file, my lord. It's file, my lord.
Yes.
Relist the matter on 11th, can you file?
Yes,
my-
yes.
You forget instruction.
Yes,
Yeah, we'll close it.
please.
Lordship, it is our same accident, Lordship.
Same accident.
In this case, Lordship,
Death case, my lord.
death case, Lordship, the deduction has been one third ಆಗಬೇಕಾಯ್ತು 150% deducted, Lordship. It is the first one is a married woman, wife, Lordship, the deceased wife. The deceased was working as much of Hescom. He's after retirement, he was getting a salary pension of amount of rupees 40,573. I am not disputed that amount, Lordship. The deduction is only to the one third, Lordship, but the tribunal has committed an error in 50% has been deducted, Lordship. The coordinate bench of this court has been already.
Petitioners are the
Wife and
children.
sons, Lordship. Two sons, Lordship.
Let it be with that only.
One third.
No, correct. The 20 and 21 must be taken together, common,
Yes.
isn't it?
Yes.
But it is separate, Lordship. That is, it is a minor. It is a case of death case, Lordship. It is disposed, Lordship, that.
Not separate.
Only one ground is the adjournment. Deduction is only to the extent of 50% as deducted, it comes to one third. That reason I was seeking an answer. Illegal.
My lord, because they are major sons and wife, she is entitled. But Virendra case in para, it has been discussed, pension is not an criteria for deducting the compensation amount. So on that ground, it may be allowed. Virendra case.
That ground?
It may be allowed.
The coordinate bench of this court, Lordship, the only soul in that case, Lordship, the wife is there, Lordship. In this case, Lordship, the sons are also there in my case. Para number 14, Lordship.
14.
Yes, Lordship. Page number 12.
But in this case, 50% she was getting.
This is allowed with. One third is half is one third.
Yes.
Only that is the change which will be there.
Yes.
Rest of the things remain.
But one condition, there is a delay of 103 days condone, but the claimants are not entitled for the delay period.
Interest.
138 days illa.
No interest.
103 days.
Bill is allowed. To the extent that appeal is partly allowed.
Number 22, Basavaraj Kareddy.
Lord, I beg to appear for appellant.
Yes.
I appear for the respondent. It is a land loser case. Land loser case, my lords. Appointment of petitioner, respondent in land loser case. Learned single judge is allowed.
If it requires hearing, we'll have it in the regular combination next week.
It requires hearing, Mal.
Relist on date. Yes. Next.
Mahatesh Patil.
A divorce petition filed by the respondent husband is allowed, my lord, on the ground of adulterous count. It requires hearing, my lord, it may be taken on next week indeed.
We list on.
It up next week.
Post. Relist the matter on.
Betty.
20th. After my number 5.
Lord, I appear for respondent 1 to 3, my lord. Lord, 1, my lord, last occasion notice is ordered, it appears, but not yet received by the my lord MD. Anyhow, if my lords permit, my lord, I come on record for my lord.
Lord Counsel Sri Darshan undertakes to appear for respondents 2 and 3.
And presently, my lord, 2 and 3, I have filed a wakalat, and 1 also, my lord, notice yet. I'm probably awaited.
Undertakes to appear for R1.
R1 also, please.
Now you take your stand on the main matter.
Yes, my lord, the matter, my lord, with regard to my lord, consideration by my lord, the respondents of the my lord, who were arrived, my lord, who have arrived and my lord, parties to the writ petition. Within my lord 8 weeks, it was ordered. And however, my lord, after going through my lord verification and my lord thorough verification by the JESCOM my lord officials, it has been found that the tower installed by the my lord KPTCL, which is since my lord 1922, my lord, it is in the existence, and accordingly it is been communicated to the KPTCL. KPTCL in turn, my lord, has confirmed that yes, it is my lord the tower coming under their jurisdiction. And however, the my lord said tower is my lord, it is my lord not affecting the my lord any my lord landowners or my lord any cultivators.
Endorsement.
Endorsement, my lord, given to the advocate on record for the petitioner. Yes, my lord. That is by us, my lord. It was given on 12/4/2024 after a belated stage, my lord. But that copy has to be, my lord, furnished, my lord. I will furnish next. Yes, ma'am. Next date of hearing.
Relist the matter on.
Obliged. Much.
In serial number 4, interim order may kindly extend earlier granted interim.
Interim order in operation is extended till the next day. Bench. Bench. The 230 single is different. Huh? ಇಲ್ಲ ತರ್ಸಿದ್ಮೇಲೆ ತರ್ಸಿದ್ರೆ ಬರ್ತದೆ 230 ಅಂತಲೇ ಏನಿಲ್ಲ ಅದನ್ನು ತಿರ್ಗಾ ಬೆಂಗಳೂರು ಹಾಂ ಬ್ರಾಂಚ್ ಕೇಳಿ ಒಂದ್ಸತಿ ಫೋನ್ ಮಾಡಿ ಏನು ಬರಂಗಿದ್ದು ಒಂದು 5 ನಿಮಿಷದಲ್ಲಿ ಮುಗಿಸ್ಕೊಂಡು ಹೋಗ್ಬೇಕು.
नहीं वो क्या क्यों सर्विस रिपोर्ट क्या 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 देखना है वो मैडम बस सीरियल नंबर 5 फिर क्या करते हैं पीसी हाँ खत्म होते मेरा फाइल है ये फाइल कहाँ घूम गई थी क्या फाइल क्यों नहीं? दो रेट है अप्लाई कर एक कॉल के साथ घास कर लेते घास कर लेते फिर क्या करते मैडम सीरियल नंबर 5 ನಲ್ಲಿ ಆರ್ಡರ್ಸ್ ಸರ್ವಿಸ್ ರಿಪೋರ್ಟ್ सीरियल नंबर 5 WP ಅನ್ನಂಬರ್ಡ್ ಹೊಸದು ಇಲ್ಲ ಬೇರೆ ನಾಳೆಗೆ 2:30 ಮತ್ತೆ DB ಕೂಡ್ತಾರಂತ ಹೋಗಿದಾರ ಹೇಳ್ಬಿಡ್ತೇನೆ ಹಾ ಹಾ ಇಲ್ಲ ಮೆಮೊ ಕೊಟ್ಟು ಕಳ್ಸ್ಯಾರ ಅಂತ ಹೇಳಿ ರಿಟ್ ಅಪೀಲ್ ಮೆಮೊ ಕೊಟ್ಟು ಕಳ್ಸ್ಯಾರ ಅನ್ನಂಬರ್ಡ್ ಹ್ಮ್ ಹಾ ಅದು ಮೆಮೊ ಮ್ಯಾಗ ನಂಬರ್ ಬರೋದ್ ಬಿಡ್ರಿ ಫಸ್ಟ್ ನೀವು ಮೊದಲು ಅಪೀಲ್ ಫೈಲ್ ಮಾಡ್ಬಿಡ್ರಿ ನಂಬರ್ ಅಲ್ಲಿ ಕೊಡ್ರಿ ಅವರು ಬಂದ್ರೆ ಕಾಣ್ತದೆ
to board elections. High command, high command. Qualification.
Each time granted for necessary compliance.
So, for the petitioner, 1 week time.
Time granted for necessary compliance.
Please.
One more.
Sir.
Yes, you are appearing, is it?
Sir, as instructions are there here, sir, we will
good.
undertake to
Appear.
appear for the petitioner on this matter.
Now, who is the
Ganesh Kalaburagi and Anand Jagir.
so and so undertakes to file wakalat on behalf of the petitioner? Now, what is the main matter? Who is the answering respondent?
Yes,
Who is the answering respondent?
answering respondent is the only the respondent number one, your lordship. He is the plaintiff who has filed an application for amendment of the plaint, and same day it was allowed without giving an opportunity for me to file objections and hear. File and review that application is rejected, it is not maintainable.
Who appeals now? R1 is served.
R1 is served.
The other respondents are not necessary.
They are the co-defendants, your lordship.
Huh?
They are the co-defendants.
Co-defendants.
The application for amendment,
They are sailing with you.
they are selling
They are sailing with you.
separately. They are appeared through other councils, your lordship.
Correct, but they are the
1 to
defendants along
yes,
with you.
only yes. D1 to 3 are appearing for the same councils, means that is the
1
petitioner.
to 3.
Hmm.
Anand then
And
Venkat.
defendant number 4 is served, is not here.
What order you have challenged?
Your order is annexed. Your lordship, an application for amendment of the plaint was filed on 16/2/2019.
Hmm.
That application was allowed on the same day, without giving me an opportunity to file objections and without giving an opportunity.
Correct. What is
So
the,
that application, according that, I have filed an application to review that order. That
But-
application is
correct.
rejected, your lordship.
correct, what is the nature of amendment?
By virtue of that, he want to delete some property from the schedule of the property.
Suit for,
Partition and separate position.
but do you have a claim?
And-
with this?
Yes,
Do you have a claim? You're
Yes.
saying that those properties,
one, para number, sorry, page number 20, your lordship, annexure B.
correct. They want to delete,
Some of the properties they want to delete, your lordship, and some,
so correct, so now
Yeah.
the point is, if according to you, that has to be a part of the schedule.
yes,
Nothing prevents you now from filing a counterclaim with respect to that. By filing consequent to the amendment, if according to you, no, those properties also have to continue to be a part.
if it I wouldn't heard on that aspect, your IA, matter would have been.
No, correct. Now
yes.
you are the first defendant, isn't it?
Yes, yes,
You are the first defendant.
yes, yes.
Now the plaintiff has filed the application seeking to delete certain items.
Yes, yes.
That has been allowed. So what is your contention? Why that amendment should not be allowed? If according to you,
Yes,
it will help you only. It goes outside the purview of the suit. How is it going to prejudice you? Now, once the amendment is allowed, you can always file an additional written statement insofar as such amendments are concerned. What is the ground taken in your review petition?
I have not been heard, your lordship. My objections, my opportunity to file objections, and I have not been heard while passing that order. That was the only thing which we have taken the objection.
Apart from the schedule, any other amendment is effective?
No, your lordship. So in para number 3 also they sought certain amendment regarding clarification of the endorsement nature of the property. Para number adding in additional para number 3A that the plaintiff and defendant number 1 are constituted an undivided joint family. There is no partition. Plaintiffs have half share, successor and joint family properties. 4A is also added.
What is the stage of the suit now?
I think it is interim order is there, your lordship, it is for evidence stayed.
Stay.
Stayed.
R1 is served, nobody for R1.
Yes.
So where is the order? Let us have a look at it.
It is as page number 50,
Page?
53, your lordship.
No, just read the order letter.
Yes, sir. The applicant is the defendant number 1 has filed interim application number 6 under section 114 read with section 47 read with rule 1 of the order 47 rule 1 of the CPC. The advocate for defendant number 1 has filed memo of facts along with said IA number 6 and has stated that on 16/2/2019 the plaintiffs had filed interim application under order 6 rule 17 read with section 151 of CPC seeking the amendment of the plaint which was numbered as IA number 1 and the application accompanying affidavit dated 12/2/2019. The court, without seeking objections of defendant number 1 and without giving the defendant number 1 opportunity to file her objection to the said application, has allowed the said application on the same day, on 16/2/2019 itself, and directed the plaintiff to amend the plaint. And on 22/2019, the plaintiff carried out the amendment. The counsel for the defendant number 1 has stated in the memo of facts that when the said counsel sought to file her objections to IA number 1, at that time the defendant number 1 has come to know the said IA has been already allowed without giving her opportunity of hearing. The plaintiff had sought amendment which is materially alterated the nature, character of the suit by way of amendment of the plaint. There is error on the face of record and other sufficient reasons, hence it is necessary to set aside amendment and give the opportunity to the defendant number 1 permitting her to file objections to the application for amendment of the plaint and allowed on 16/2/2019. The advocate for plaintiff has filed objections here. Your Lordship. The
Now, do you have a copy of the order allowing the amendment application?
it is there in the part.
This is the review. This is the order on the review.
Yes, sir. I have filed the entire order sheet, wherein at page number,
No separate order, is it?
I will. Page number 45, Your Lordship. Last one, 16/2/19. 4/5. Typed copy is there, Your Lordship.
Astena.
Astir.
No separate order.
No separate order. Sri AP Advocates files IA under 6 Rule 17 read with section 150 CPC and also heard the plaintiff and allowed the IA.
You're sure? No separate.
It is there, Your Lordship. It's at page number 43, of which the typed copy is at 45.
Now, the review is maintainable even against an order on an IA.
I have not been, that is on the face of the record.
No, I'm saying review
Yes, yes.
is maintainable even against an order on an IA.
If it is on the face of the record, there is error, it is maintainable.
So even against an interim order, review is maintainable.
Is there, Your Lordship? The ground which they have said, the trial court has said that I have to challenge that order of 16/2/19. Instead of I have filed review, that is not maintainable what they have said.
That's what the impugned order says.
That is.
CPC couldn't. Otherwise, we have to treat that IA.
Yes.
Your review petition is one for recalling the order.
Yes.
Because you were not heard. You were
Yes.
not heard.
Yes.
Huh?
In the amendment matters.
Correct.
Yes. If I have been permitted
To
to
participate.
or to file objections, whether the amendment is just or to decide the matter on merit, I have been heard, then that matter could have been different in that aspect.
So the application itself may be treated to be an application filed to hear you, to recall the order, hear you, and pass fresh.
Yes,
We can treat that IA as, though it's styled as a review petition,
yes,
can be treated one to recall, reopen,
yes,
give you an opportunity and pass an order.
yes. That is the only thing.
Huh?
Yes,
Under 151.
yes.
So then we'll dispose it off like that.
But
What's the point in keeping it?
that is the only thing, Your Lordship. I may be permitted, I may be heard, and necessary order may pass. That is one item.
That order was passed on the same days.
Same days. It is page number 45 is the typed copy, and 43 is the order wherein it is in written form. 43, Your Lordship, last. Sri AP's advocate, file I-1 under order 6 rule 17, read with section 150 CPC.
Typed copy at page?
At page number 45, Your Lordship.
But you have not filed any written statement, isn't it?
Written statement is filed.
The order sheet says you have placed ex parte.
No, I am defendant number 1, Your Lordship. AMP advocate is representing me.
You have filed a written statement.
WS is filed. The copy is also filed.
Before 2018, WS of P1, taken as not filed on
That is a
page number 37.
page 5.
Now, where is your IA? Where is your IA?
I is at Annexure C, Your Lordship. Page number 23.
So we'll treat this as an IA for recall.
Yes,
Allow it and remand it.
much obliged.
So since when the suit has been stayed,
Order from 8 to 21, you.
the present petition is by defendant number 1 in the suit OS 91 of 2017, who has challenged the order of the trial court passed on 16/2/2019, whereby the application filed Order passed on 30/11/2019. 30/11/2019. Whereby IA number 6 filed by the defendant under section 114 read with order 47 rule 1 of CPC has been dismissed with cost. The brief facts made out and as are relevant to the disposal of the present matter is that the plaintiff had filed OS 91 of 2017 seeking for passing of a decree of partition and in specific has sought for passing of a preliminary decree partitioning the scheduled properties to the extent of half share of the plaintiff, comma, pass a decree for cancellation of the registered mortgage deeds executed by defendant number 1 in favor of defendant number 2 and 3, and for a declaration that the same are not binding on the plaintiff in respect of the half share of the plaintiffs in the suit scheduled properties, comma, decree for mean profits of rupees 5 lakhs in favor of the plaintiff as against defendants 1 to 3. During the pendency of such during the course of such proceedings, IA number 5 came to be filed by the plaintiff seeking for amendment of the plaint, seeking to delete certain item in the suit schedule and also seeking to add certain governments as detailed at para 3A, which is the proposed amendment to the plaint, as well as para 4A. It is the case of the defendant that said application came to be filed with an affidavit which only mentions that the proposed amendment was not sought earlier, which is a mistake, and that changes in the survey number came to the plaintiff's knowledge subsequently, and accordingly, the application deserves to be allowed. Said application to be filed on 16/2/2019.
Yes.
And that application was heard and disposed of itself on the same day, as is evident from the proceedings reflected in the order sheet on 16/2/2019. Full stop. It is the case of the defendant that application was allowed without affording an opportunity for the defendant to file statement of objections in the said application. And accordingly, the defendant has sought to file an application under section 114, read with order 47, rule 1 of CPC, seeking to review the order dated 16/2/2019, whereby the interlocutory application filed by the plaintiff came to be allowed, and to set aside the said order and permit the applicant, that is dependent number 1, to file objection to the said interlocutory application. The defendant has filed, the counsel for the defendant has filed memorandum of facts in support of the said application, and submits that the defendant number 1 did not have any opportunity for hearing, and application was allowed on the same day. It was specifically a word in the memorandum of facts that the proposed amendments by insertion of pleadings has the effect of materially altering nature of claim and nature and character of the suit. Next, it was submitted that the order passed suffers from error on face of record, and accordingly, order of 16/2/2019 ought to be reviewed and opportunity granted to defendant number 1 to file statement of objection. It is noticed that the writ petition came to be filed in the year 2020, and interim order granted. Interim order was granted
8/2/21.
on 8/2/2021, and matter remains in the same stage despite lapse of about 4 years. The contesting respondent is respondent number 1, who is the plaintiff before the trial court. As the application was filed by the plaintiff, only contesting party is the plaintiff. However, the plaintiff, though served with notice, has not appeared before this court. Insofar as the other respondents are concerned, it could be taken that defendant number 4 is represented by the AGA, while the other defendants, namely defendant number 2 and 3, are co-defendants, and notice may be waived as regards such co-defendants, as the defendant number 1 sufficiently represents the interest of the other defendants insofar as objection being raised to the amendment application. Accordingly, noticing that the plaintiff has been served, matter is taken up after waiving notice to the other two defendants, that is respondent number 2 and 3, who are defendants before the trial court. Next. The suit is one for partition. Application for amendment has been filed, seeking to amend the schedule, as well as insert certain averments in the by way of proposed amendments. A perusal of the proposed amendment would indicate that an alteration is sought as so far as the description of the property by way of deletion of survey number 37. Apart from such amendment, the plaintiff has sought for insertion of para 3A, wherein there is a specific averment that there was no partition amongst the parties in respect of suit scheduled properties, that the plaintiff has half share in the suit scheduled properties along with defendant number 1. Full stop.
My lord,
Further, specific governments are made in proposed para 4A that
I may permit to.
that regarding change in the revenue entries and rectification of record of rights by way of revenue proceedings. Next. There is a force in the submission of defendant number 1 that the proposed amendments required an opportunity for defendant number 1 to file objections insofar as the governments relating to description of property by virtue of proceedings on the revenue side are factual assertions that required a rebuttal. It is submitted that if opportunity is not granted, it may have consequences in the event the suit is decreed at the time of final decree proceedings, wherein demarcation of the property is required to be made. Full stop. It is submitted that the change in the survey numbers as is narrated in the proposed amendment are matters that have to be clarified by the defendant, which would be possible only if opportunity was granted to file objections to the IA for amendment. Next. It is peruse the order for amendment passed on 16/2/2019. Order passed allowing the amendment application is bold with no reasons assigned for allowing such application. Next. Peruse the order passed dismissing IA number 6 filed seeking review of the order. The trial court has observed that the defendant number 1 ought to have challenged passing of order of amendment in appropriate proceedings and ought not to have filed an application seeking review of the order. It's also observed that application filed as IA number 6 is supported by memorandum of facts and the same has been filed belatedly. Next. Point for consideration is as to whether grounds are made out to interfere with the order passed by the trial court. Whether the submission of counsel for the defendant that the application may have been treated as one to recall the order and provide an opportunity of filing objections requires acceptance. Next. Third learned counsel for the plaintiff. As pointed out above, order allowing the amendment application is cryptic. No reasons are assigned. As rightly pointed out by the defendant number 1, proposed amendment, which includes paragraph 4A, wherein assertions are made regarding renumbering of survey numbers. And such aspect would have an implication as regards identity of property, especially at the stage of final decree proceedings, as rightly asserted by counsel for defendant number 1. Notice that the said application was allowed on the same day on which it was filed. Prima facie, the order is passed in violation of principles of natural justice as well, insofar as the defendant ought to have been allowed sufficient opportunity to file statement of objections to the said application. Even if defendant number 1 were placed ex parte, there is no bar on the defendant from objecting to such application for amendment.
He was not placed expert. He was represented by the counsel.
Just check. Let us see, just check it.
5.
Next. No doubt the trial court has observed that the application for review ought not to have been entertained, and the defendant could have challenged the validity of the said order in appropriate proceedings. It is a settled position that procedural requirements relating to provision of law under which application is filed must be construed liberally, keeping in mind ends of justice. Though the application is filed describing it to be an application seeking review of the order passed, the application could be construed as one filed seeking to invoke inherent powers to recall the order of amendment allowed without hearing of the defendant number 1. Substance of the petition application for review is to recall the order allowing the application and to permit the defendant number 1 to file statement of objections. The application, though filed as a review, may be treated to be one filed seeking to recall the order passed and to afford an opportunity to file statement of objections. Taking note of the factual matrix as noticed above, the application filed may be treated to be as one seeking to recall the order passed on 16/2/2019 and to permit the defendant number 1 to file statement of objections to the said IA. Accordingly, we find that the trial court has adopted a unduly conservative approach in dismissing the application. In light of the discussion made above, the points for consideration are answered in the affirmative. Application is allowed. The order of 16/2/2019 dismissing allowing the amendment application is set aside, and IA number 6 is allowed. Necessary statement of objections to be filed to IA for amendment within a period of
Any short.
2 weeks.
Yes.
Within a period of 2 weeks.
Yes.
Trial court to take up IA number, IA for amendment and reconsider the same in accordance with law.
But
Accordingly, petition is disposed of.
on 2011-2017, defendant number one is appeared through one advocate, your lordship.
As
Advocate has appeared through, defendant number one is appeared, wakalat is filed.
written statement,
Written statement taken as not filed.
that's okay. I've said that
I
will not-
appeared, but written statement has
Correct.
not filed.
So I've observed that that will not bar you from filing your objections to the amendment.
But
Number 4. Harvardkar to both Tripathi.
May I please?
Yes.
Sir, this suit seems to have been disposed in the trial court, sir. There was an appointment of, there was police protection given by the court. For non-compliance, it has been ordered, sir.
No, correct. But in light of disposal of the suit, it doesn't survive contention. I'll keep it open.
That's my request to the court would be, I may be permitted to withdraw to file such application in the RA which is pending before the appellate court.
Yes, 105.
Yeah, police protection. 151, we had sought application to seek police protection.
Correct. So what I'm saying, that under section 105 of CPC, you can raise the substance of whatever you have raised in your writ petition by way of appropriate proceedings in the RA.
Please,
As against the impugned order.
Please.
105, isn't it?
Sir, initially police protection was granted to me in an injunction suit on interim application.
No,
And
I'm not
let-
on that point. I'm not on that point. I'm saying that the right to challenge an order not challenged before the appeal proceedings is under 105, isn't it?
Yes, yes.
The is noticed from the case status report that the suit of the plaintiff is dismissed. It is submitted that an appeal is pending.
Yes, sir. RA number 71/23.
Appeal. RA number
71/23 pending before additional senior civil judge Sindhi.
number 71 bar
23.
is pending. In light of the said development, the present petition.
I'm plaintiff in the trial.
Yes, yes. Present petition is sought to be withdrawn. You seek to withdraw.
Yes, sir. Withdraw and permission to file such application before the appellate court.
Is sought to be withdrawn by counsel for the petitioner who appears through video conference. In light of such request, petition is dismissed as withdrawn. The contentions and objections insofar as the impugned order is concerned are kept open to be raised as is permissible under law in the pending regular appeal.
Please. Please.
Accordingly, proceedings are disposed of. Yes.
Number 5, Vinayak Apte.
I'm petitioner, my lord. Vinayak Apte on behalf of my inconvenience, my lord. I will attend Monday or Tuesday, my lord.
At request, relist the matter next week.
Interim order extension, my lord.
Interim order fast is extended till the next day.
Okay.
Yes.
Ramachandra ke.
Being non-compliance. Representation on behalf of the petitioner. Is adjourned.
Petitioner.
Yes,
Lords, notice to respondents 5 to 7 may kindly be dispensed with. They are co-plaintiffs, Lords, along with the writ petitioner in the.
file a memo.
Yes,
Notice to
respondent 5, 6 and 7.
respondent number 5 to 7. Is dispensed with. In light of the submission that the said respondents are co-plaintiffs.
Yes.
Such order is passed at the risk of the petitioner.
Please.
What about R6?
5 to 7, 5, 6 and.
What
Yes.
about R6? 5. Yes. Now who is the contesting?
Lords, respondents 1 to 5. They are the Lords defendants before the trial court. After Lords closure of the evidence, Lords application for appointment of court commissioner was filed by the plaintiffs, Lords. That came to be rejected, Lords, against which Lords this writ petition is filed.
What is the stage of the proceedings now?
Lords, evidence is closed. Now, Lords, this honorable court has granted the interim stay of the proceedings.
Who appears for the other side?
Kallur sir appears.
Is he there? No.
Today I have not seen him. Banda?
Shall we have it tomorrow?
Tomorrow, tomorrow.
Day after tomorrow?
ಇಲ್ಲ ನಾನು 2 ದಿನ ಊರಲ್ಲಿ ಇರೋದಿಲ್ಲ ಸ್ವಾಮಿ ಅಥವಾ ನಾಳೆ ಇಟ್ಕೊಳ್ಳಿ ಪರವಾಗಿಲ್ಲ ಐ ವಿಲ್ ಅಟೆಂಡ್ ಅಂಡ್
No, no, we can have it next week, that's it.
tomorrow we'll take a chance. If there is some inconvenience, I will seek for adjournment.
We'll list tomorrow.
Please.
Mantesh Party.
Idrala. Password.
Right? Chaitanya Kumar.
No, I am praying for the petitioner in this matter.
Is a fresh matter, is it?
Fresh matter, my lord. Lord, office objection is that, my lord, the respondent number, my lord, the 3, 4, 5 and my lord 6 are not there in the order. My lord, since my lord, my lordship may kindly see, my lord, ink page 19. My lord, plaintiff number 2, Neelamma has died, my lord. They are legal representative of Neelamma.
Plaintiff number
2.
Neelamma.
Please, my lord, she has died.
So
My lord.
she has died where during the pendency of proceedings? Or?
No, my lord, after proceedings has been completed, she has died. Now writ petition is filed, my lord, the legal layers of my lord, the deceased Neelamma has been made as party as the respondent number 3, 4, 5 and 6.
Is the
Please.
order passed by the Lok Adalat?
Please, my lord.
Office objection is kept in abeyance for the present. Now, notice must
Notice may be issued.
issue notice to the respondents.
Much obliged.
Password.
Number 11, Sangana Basava Party.
Fair one. My lord, the petitioners are the plaintiffs before the trial court.
Petitioners are the plaintiffs.
Plaintiff before the trial court, my lord.
Ah,
The petitioners have filed suit for permanent injection and mandatory injection, my lord.
filed a suit for
Permanent injection and mandatory injection.
Ah.
Injunctions. The IA number 2 is, my lord, Order 39 Rule 1 and 2. As per Annex G, my lord, earlier, my lord, temporary TA was granted. The present response, my lord, is the dependent. He filed a caveat. The court summons was served to the caveat. They are refused, my lord, for Annex F.
No, you are challenging an ex parte order.
No, my lord. After the TI, my lord, they file IFR 151 CPC for recall that order, my lord. The court below was recall the order, man.
Recalled.
Recall the order, man.
You are the plaintiff.
I am the plaintiff, my lord. Initially, TI was granted to us, my lord.
No, correct.
Yes.
Now what has happened? What has happened to the proceedings before the trial court?
My lord, now there is interim order of stay, my lord, before this honorable court.
No. Interim order stay only of the impugned order.
Interim order of stay.
There is no stay of the proceedings. Stay of operation of impugned order.
Yes, my lord.
What has happened to the suit now?
Suit going on, my lord, for yeah, stage ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ stage.
Case state is stay.
Proceedings are stayed and there is no progress, my lord, what I could.
That is wrong. Nobody has stayed the proceedings. What has been stayed is only the order.
Please.
So proceedings must go on. Why is the proceeding?
Lord, matter lies in very narrow compass. my lord.
Correct.
The ex parte order was passed, my lord. I have filed a caveat before the trial court, my lord. Instead of giving.
Caveat is at annexure?
Annex A, my lord.
K.
A, my lord. Annex A, my lord.
Date of filing is 8th April.
Yes, ma'am.
8th April 22. Suit filed on
16, my lord. 16 April.
16th April 22.
2, ma'am.
So that's all. He had to be notified.
My lord, the court summons was.
Yes, my lord.
You have to be notified.
Yes,
please, my lord.
And then heard and then order passed.
Please.
Only on that ground order is recalled. That's all.
The court issued the notice, my lord, for court commissioner emergency notice. The respondent caveat is refuse the notice, my lord. By the next F, my lord, page number 41.
Page
41, my lord.
Correct.
Yes.
Now, once a caveat is filed,
yes, ma'am,
you have to serve a copy on the counsel for the caveat.
Please.
They
That
refuse,
is
my
the
lord.
main contention.
They refuse, my lord.
Second.
Yes.
Page 40.
41, my lord. Next F, my lord. May I read, my lord?
No, this is insofar as notice on the caveat petition.
Yes, ma'am.
However, when a caveat is filed, you must serve on the counsel for the caveat.
Yes, ma'am. But my lord, the court summons and emergency notice are issued. They refuse, my lord. Kindly see the.
Lord,
Page number
what happened, one more thing in my lord, that on 21st, my lord, the matter had been posted. 22nd, 4, my lord, matter has been posted. But the plaintiff's counsel filed an advancement petition on 21/4, saying that the defendant has refused notice, so order may be passed.
Where is the order sheet?
Order sheet.
Annex G, my lord. Page 47, my lord. 47 or 48, order annexary. 48, my lord.
Case is advanced.
Case was on 22nd. 21st, it was advanced and an ex parte order was taken. I appeared on 22nd and apprised the court of the things. Then this order was recalled and matter was posted for written statement and objection. Instead of filing objection and written statement, he has approved this honor. So my humble submission is that the writ petition is premature. He would have contested the matter there by filing a written statement and objection.
Where is the order recalling the injunction?
My lord, annexure K, my lord, page number 62, my lord. Case called that defendant counsel filed a memo.
On 21st, you have filed wakalat. On 21st, you have filed wakalat. Page 62, order sheet.
Yes, madam.
On 21st April.
Advancement application is taken on board.
Now the order is passed by the trial court.
Filed wakalat on.
Interim order is passed by the trial court on
20th, my lord. 20th April, my lord.
on 20th.
Yes.
On the 19th, case was adjourned. And case was adjourned on 19th to 22nd. Initially.
Please.
Court said we have to hear the other side. Meanwhile, he filed an application for advancement.
Please.
And sought for passing of interim order on 20th. And on 20th, order is passed. Isn't it?
Please, ma'am.
After advancing the case. Now, in case a caveat is filed, why do you take out notice directly? You can serve on the counsel for the caveat.
Please, ma'am. That is my contention.
Huh?
Yes, ma'am.
Now, if we were to dispose it off, directing the trial court to hear you and pass a final order,
Please, ma'am.
that would suffice.
Please.
Yes.
Now, you have filed objections to that IA or still to file?
In the trial court, my lord, that I have no.
Will permit you to file order 39, rule 4.
Please.
And objections. And that must be considered and IA disposed of within a reasonable time.
Please.
Till then, the interim order will continue.
Continue.
Status quo.
No, ma'am.
Status quo, madam.
What is the
Status
order
quo would
passed?
serve
now?
the-
What is the order passed now?
TA was granted by this honorable court in the vacation bench, my lord.
What is the order passed?
On 10th April 2022, my lord.
Huh?
10th April 2022, my lord.
But MA was filed and then withdrawn as not
Yes.
placed.
Yes, madam.
Because it was an against an ex parte order. Now, what is the order passed? Page?
Page 62, my lord.
We'll alter it to status quo, that will again serve your purpose.
Please.
My lord, there is an interim order by the this honorable.
Now, we can dispose it off
Yes, ma'am.
by stating that the order of temporary injunction will now be modified to an order of status quo by both the parties till the disposal of the IA.
Please.
Yes, ma'am. Well, instead of let's come on a TI, we continue, my lord, early, if they're not, yeah, again, they can
be
start the construction
same, my lord.
building, my
Effect
lord.
would be the
No,
same.
no, status quo as on date, we will observe. And the photographs to be produced by both sides along with the memo within 1 week before the trial.
What happened, my lord, in this case, my lord?
No, no, what we are saying, I will say, the status quo, the position of the property should be brought to the notice of the trial court by photographs to be filed by both sides
Please.
within 3 days from today.
One more submission,
Ah.
one more submission.
Ah.
After the TI, my lord, the different started construction, my lord, hence I filed the contempt petition before this honorable court for this honorable court, my lord. This honorable court was given liberty to file contempt petition before the appropriate court under Order 39 Rule 1
So
2.
we'll clarify
Yes.
that this order will not come in the way of any proceedings initiated earlier by you.
Yes,
We'll dispose it off.
yes, ma'am.
So
ಯಾಕಂದ್ರೆ
by consent, we'll dispose it off on the following term.
ನಮ್ಮ ಅಪ್ರೋಚ್ ಏನು ಸ್ವಾಮಿ ಅಂತ ಇದು ಟಿ ಐ ಇದ್ರಸ್ದಿಗೆ ಅವ್ರು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರು ನಾ ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದ ನಂತರ ಮತ್ತೆ ಅದು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟೆವು ಅವಾಗ ಅವ್ರು ಮತ್ತೆ ಸ್ಟಾಪ್ ಮಾಡಿದ್ರು ಮತ್ತೆ ಅಲ್ಲಿ ಇವಾಗ ಅಲ್ಲಿ ಕಂಟೆಂಪ್ಟ್ ಪಿಟಿಷನ್ಸ್ ಅದು ಪೆಂಡಿಂಗ್ ಇದೆ.
Correct.
Honorable court is asking
This-
us to file the photographs.
Yes, ma'am.
That's said.
This order will not come in the way of any proceedings already instituted.
Please, ma'am, please.
The present petition has been filed by the plaintiffs before the trial court. Calling in question validity of the order dated 22/4/2022, whereby ex parte order of temporary injunction passed on IA number 2 came to be recalled
Please.
on the ground that the caveator was not served with notice before passing of order on IA number 2. It is the case of the plaintiffs that suit was filed for permanent injunction against the defendant not to encroach and construct building in the public road as described in the schedule. Full stop. Plaintiff had also sought for issuance of mandatory injunction against the defendant to vacate the illegally constructed shed as indicated in the sketch. Full stop. Further allied reliefs were also sought for. Next. Admittedly, caveat petition was filed by the defendant. However, it is the case of the plaintiff that without serving the counsel for the caveator, the plaintiff has advanced the suit relying on notice issued to the defendants, though they were represented by a counsel as they had filed a caveat, and relying on such endorsement of service on the caveators who are stated to have refused service. The plaintiffs have moved and got an order passed on IA number 2 of injunction. Next. The counsel for the caveator submits that Court ought not to have relied on notice of service on the caveators in person when counsel who filed the caveat petition was always available for being served with the notice of the suit. After hearing the matter for some time, matter is disposed of by consent as follows. 1. The IA number 2 to be heard on merits by the trial court. Full stop. Defendant to file statement of objections if not already filed within a period of 2 weeks from date of receipt of certified copy of the order. Full stop. Both parties would maintain status quo as on date till disposal of IA number 2. Memo to be filed by both sides along with photograph to indicate position, to indicate status of property as on date. Such memo along with photographs to be filed within a period of
2 weeks.
Huh? Photo. Yes. How much time? The quicker you do, at least the court will know what is the status of property. Within 1 week, haktira?
1 week.
Within 1 week, please. Full stop. All contentions of the parties are kept open. Petition is disposed of in terms of the above observations. Needless to state, the alteration of the order of needless to state, order passed in the present proceedings will not come in the way of contempt proceedings stated to have been filed by the plaintiff. Yes.
Number 12, Deepak Bharat.
I have a 2:30 list of video conference, Bangalore matter. We'll repeat the list tomorrow.
One serial number 18 next week.
Next, serial number?
18.
18. Serial number 18. At request, you informed.
I have informed.
Relist the matter next week.
Yes. For serial number 12, I am withdrawing the petition.
Serial number 12. Counsel for the petitioner files a memo.
Since the suit itself is settled in Lokadal.
And submits that the dispute between the parties is settled at Lokadalat. And accordingly, suit itself has been disposed of. In light of the same, petition is dismissed as having become infructuous.
Serial 21 and 23.
Yes.
I'm up to 10th. I'm not here in session.
21 and?
21 and 23.
Next week.
Next week.
After 10.
After 10.
21 and 22. List after 2 weeks.
23.
Intermodal operation is extended till the next year.
Serial number 7. My lord said adjourned it to tomorrow. I am informed Kallur sir has gone to Mahakum. He will be next week.
7. Relist next week.
Please.
Serial number 14.
Next week. 14. You have informed the other side.
I informed them.
At request of the respondent. This is the matter next week. Yes.
Lordship, serial number 17 and 19 interim order is there. Serial number 17 and 19. Interim order.
17, 19 interim order in operations is extended till the next date. Whatever we don't take up today, we'll repeat tomorrow unless it's urgent.
22. Serial number 22. Sole respondent is there.
22. Fresh matter.
22.
Correct.
Sole respondent is dead, my lord. He has to.
Is dead. 22. Submitted that the sole respondent has died. Full stop. Necessary steps to be taken. Full
20
stop. Week after next.
serial number 20 next week. I am for response. 20 20.
You've informed the other side.
I shall.
At request made on behalf of the respondent. List the matter
Next week.
next week.
8, there is an interim.
Huh?
8.
Eight. Wherever interim order
I-
is there, it will stand extended.
Lordship, serial number 24.
Huh.
Date may be fixed. Your Lordship.
Today is the date. Huh. At, you appear for
I
the,
appear for a petition, appel petition.
at request. When do you want? Tomorrow get ready.
Please, please.
Relist tomorrow.
Tomorrow about some 19th or 21, Lord.
Huh?
19th or 21, Lord.
And if you're there tomorrow, do it. I also don't have work. You want to do it tomorrow, do it. We'll see.
Tomorrow on the arrest matter, Swami.
At request 24. On behalf of the respondent, list week after next.
ಸ್ವಲ್ಪ ನೀವು ಬಂದ್ ಮಧ್ಯಾಹ್ನ ಹೇಳ್ತೀರಾ 2:30 ಬರ್ತಾರೆ ಸಾಹೇಬ್ರು ಬರಪ್ಲೆ ಬರ್ತಾರೆ ಟಿವಿ ಐತಿ ಅದೇ ನೀವ್ ಹೇಳಿ
ಮೇಡಮ್ ಇದು ಸೆಲ್ ನಂಬರ್ 7 ಏನಾಯ್ತು ಅಂತ ಹೇಳ್ತಾರೆ
7 next
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲ
ಸರಿ ಇನ್ನೊಂದು ಫೈಲ್ ಕೊಡ್ಬೇಕು ಅವ್ರಿಗೆ ಒಂದು ಫೈಲ್ ಕೊಡ್ತಾರ ಅವ್ರು ಸೆಲ್ ನಂಬರ್ 1 ಕೊಂಬ ಇದು ಮಾಡಿದ್ ಮುಗಿಸೋದನ್ರಿ ನಾವು ಸ್ಟಾಪ್ ಮಾಡಿದ್ ಮುಗಿಸೋದನ್ರಿ
ಮೇಡಮ್ ಡಿ ಬಿ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಇತ್ತಲ್ಲ ಮೇಡಮ್ ಅದು ಇಲ್ಲ ಅಲ್ಲ ಮೇಡಮ್ ಮುಗಿತಲ್ಲ ಮೇಡಮ್ ಕೊರೋನೆಲ್ಲ ಒಂದು ಮ್ಯಾಟ್ರ್
9 notice. 8 password ಇತ್ತು. ಏನಂದ್ರೆ ನನಗೆ cyber List number 2, serial number 1, Ganesh Kalaburagi.
Your Lordship, writ petition was filed.
You challenge the order of the single judge.
Yes, Your Lordship, I have challenged it.
You have challenged.
Yes, Your Lordship. In fact, a writ petition has been disposed of on the ground that, yes, Your Lordship.
You have challenged that order.
Yes, Your Lordship.
Where the court has said it's infructuous.
Yes, yes, Your Lordship.
Where is the interim order at the first instance?
Yes, Your Lordship. Interim order was subject to result of writ petition.
Correct. The interim order was to the effect?
On 31/12/2024, Your Lordship, no confidence motion scheduled to be held on 1/1/2025 in the instance shall be subject to the result.
So you are saying that the court could not have.
Yes, Your
held.
Lordship. Yes,
It's
yes,
been infructuous.
yes, Your Lordship. I have taken a contention that, Your Lordship, it is not a 15 clear days notice, Your Lordships. In fact, notice was, Your Lordships, issued on 16/12, were served to the petitioner on 17/12, and meeting is on 1/1/2025.
Now what has happened now?
Now, Your Lordships, no confidence motion meeting has been held, and it has been held against the present appellant. And Your Lordships, now the notification has been issued for the election of president. That, Your Lordships, I am seeking an interim order. Yes.
Where is that notification?
Yes, Your Lordships. Along with my application for stay, I have filed it.
You should have argued this, when the court went to dismiss it as infructuous, you should have argued it.
A
how
submit-
it becomes infructuous.
A submission was made, Your Lordship, by my friend. I was not on record.
Feebly.
Yes.
ಜೋರಾಗಿ ಹೇಳ್ಬೇಕಲ್ವಾ? How can it become infructuous? Now where is the notification?
Notification is at page 34, Your Lordships. Along with my application for stay.
The AGA accepts notice for respondents 1 to 3. Emergent notice respondents 4 to 22.
Yes, Your Lordship.
It is the case of the petitioner who is the appellant in the present proceedings. That writ petition was filed challenging the notice of the assistant commissioner
Yes.
convening a meeting to consider the motion of no confidence on various legal contentions, including that there was no 15 days clear notice. It is submitted that during the pendency of the writ proceedings, learned single judge had passed an order as follows. No confidence motion scheduled to be held on 1/1/2025 in the instant case shall be subject to the result of the writ petition. Instead of close inverted comma. Next, it is submitted that thereafter the no confidence motion came to be passed in the meeting.
Yes.
And the learned single judge has disposed of the writ petition itself, observing that as the no confidence motion was successfully passed, writ petition has become infructuous. Is the further contention that once the motion of no confidence was itself subject to the outcome of the writ petition, question of passing an order that the petition has become infructuous on mere passing of motion of no confidence is erroneous. Next. Prima facie, we are of the view that once order is passed that the motion of no confidence would be subject to the outcome of the writ proceedings, court ought to have adjudicated on the validity of the notice, as once the validity of the notice was held in the negative, consequential proceedings would have to be set aside. In light of the contention raised, the holding of fresh elections to the post would create third-party interests when the very adjudication of motion of no confidence is still to be decided. Accordingly, subject to further consideration, there would be a stay of
Meeting notice dated, Your Lordships. Meeting notice dated 27/1/2025.
stay of the notice dated 27/1/2025. Stay of the notification, meeting notice.
Yes.
Dated 27/1/2025. And consequent schedule of events thereto. Full stop. It is to be observed that though the calendar of event has been issued, since the very vacancy caused due to passing of motion of no confidence is in challenge, the process of election is only a consequential proceedings. Interim order would be enforced in the next date.
Great. If I may seek for hand delivery of the order.
Address pertaining to Principal Bench, Bengaluru. Serial number 1, Suyog Herele.
Then Kodi,
Serial number 1,
Kodi.
I appear for the petitioner.
You appear for the petitioner, is it? They have no idea.
Suyog Herele. Sir, unmute ಮಾಡ್ಕೊಳ್ಳಿ sir.
The Registrar General has addressed a letter dated 4/1/2025 to the effect that clarification is sought for by the arbitrators as while considering passing of orders of appointment of arbitrator in a petition in exercise of power under section 11(6) of the Arbitration and Conciliation Act 1996. The order appoints the arbitrator with a further direction that the same is to be preceded by mediation by the same arbitrator. Clarification is sought as to whether the arbitrator could also act as a mediator. In light of the clarification sought, it would be appropriate that mediator be separately appointed, who is different from the arbitrator. Accordingly, while the appointment of arbitrator has already made for the order dated 5th November 2024 would stay, it is also observed that the mediation as ordered that would precede the arbitration is to be held, is to be conducted by a mediator, by a separate mediator. Accordingly, yes, you appear, is it?
Please, Manoj, I appear for the petitioner, Manoj.
I'll appoint a different mediator. They had only sought for a different mediator and then arbitrator. So I'll appoint a different mediator and then it would go to arbitration if mediation does not result in any positive result. Accordingly, Ms. Laila Ullapalli so is appointed as a mediator. Upon making efforts for a amicable settlement by way of mediation, such proceedings fail, matter would then be referred to mediation in terms of the appointment of arbitrator as already made. Accordingly, the clarification is sought for is dealt with in terms of the present order. The order disposing of civil miscellaneous petition 62 of 2024 is to be read in terms of the clarification made on this day. Yes. Same order, mediator dash matrimonial.
Number 3. Srimati Meera Patnagar, party in person.
I appear for the respondent, my lord.
Yes. What happened?
My lord, previous occasion, my lord, we had spoken to the advocate who was then appearing, my lord. Now, my lord, it appears they have taken back the file from the advocate. We had initiated the talks for, my lord, some kind of a via media settlement. Shrikar, my lord, Mr. Shrikar was appearing. Last time when I contacted him, my lord, he told that the file has been taken back from him.
Counsel appearing for the respondent submits that Counsel Sri P.K. Srikara had orally indicated that papers were taken back from him. Accordingly, issue notice to party in person, fixing a date. Date to be fixed in the first week of March.
Very good.
Meanwhile, you see what can be done.
Yes, my lord. There is one more, my lord, sister who is there. We are trying to contact, my lord. What is happening, my lord, is the petitioners are residents of America. My lord, Meera Patankar's brother, my lord, stays here at Hyderabad. He is the person, my lord, he is now, who was now up till now talking to all of us. I don't know, my lord, what has gone wrong. It appears, my lord, we cannot say with certainty. There is some misunderstanding there itself is what was indicated between Meera Patankar and the brother who is at Hyderabad. There is some, my lord, difference there itself is what we were given to understand. Of course, all these things, my lord, we can't, my lord, confirm. So we will, my lord, nevertheless try, my lord.
Now, this address for Meera Patankar is?
Lord, Meera Patankar, my lord, actually, my lord, resides at Dallas in Texas, my lord, USA. And my lord, Yamuna Patankar is the daughter who is again staying with the mother at USA. They are represented by one Mr. Ajit Kumar, my lord, who stays at Hyderabad. And the petition is also presented by showing that, my lord, Ajit Kumar is their power of attorney holder.
Notice to be issued to petitioner 1 and 2
at the US address.
At the US address, as well as to the power of attorney holder, Shri Ajit Kumar.
Yes, please.
Details of the address is mentioned in the cost item.
Yes, my lord. If it has to go to America, my lords may have to fix, my lord, after probably, my lord, 4 or 6 weeks, because it has to go there and come back.
Correct. So what we'll do in case the power of attorney is served, we'll see.
Very well. No difficulty, because I was given to understand there was some internal issue between them as well, which is why, my lord, I thought I'll bring it to the notice of the.
If there's any email ID of the petitioners,
Yes, my lord.
You can file it with the memo.
Very well, my lord.
The
I will
regis-
also try to ascertain, my lord, if there is any email ID.
The counsel for the respondent to inquire as to availability of an email ID as regards petitioners 1 and 2.
Very well.
If a memo is filed furnishing such details of email ID of petitioners 1 and 2, registry to issue notice by way of email to the email
In
ID
addition to the regular
indicated in the memo. This would be in addition to notice
regular notice.
notice through postal service.
Yes, my lord.
Flash
Date,
code.
my lord.
Flash code, yeah. First week of March means.
Yes, my lord. Fix it in the second week, my lord.
Date would be the- The date fix month. Relist the matter on 7th,
Very well, my lord. Very well.
7th of March, Friday.
Very well. Grateful, my lord.
But see if you can settle it there in.
No, my lord. Actually, my lord, as I submitted last time, my lord, flats are constructed, my lord, and ready for occupation. It is an internal dispute, my lord, between Meera Patankar and my lord Meera Patankar's sisters-in-law. That is, my lord, Meera Patankar is the wife of Uddhav Patankar. There's a dispute, my lord, relating to succession between my lord Uddhav Patankar's sister and my lord the wife. He has left behind a will where, my lord, certain, my lord, properties are disposed of in a particular manner. Parties are, my lord, not able to sit and, my lord, negotiate. There's actually no direct, my lord, conflict with the developer. I appear for the developer. Flats are, my lord, constructed, fully ready. And, my lord, so therefore, my lord, whoever, my lord, succeeds, we are most happy to give those apartments to them. And there is a will, my lord, there's a probate proceeding which is going on before the court. We also contacted the executor, my lord. He is an elderly chartered accountant. So we made efforts through him as well. He also tried to, my lord, convene a meeting. So this is the state of affairs. This is ready-made, my lord, hot cake, if I can put it so, my lord, for them to take, because apartments are constructed at my cost. And, my lord, it is available. Whoever, my lord, wants it can take it, my lord. Either the legal heirs of my lord Uddhav Patankar, that is Meera Patankar wife, and Yamuna Patankar can take it. Or, my lord, there's a 60-40 ratio in the will, where, my lord, 60% will go to the wife and daughter and 40% will go to the sisters, because sisters had, my lord, supported him during his time of need. So he has made a will in that manner. And so therefore, my lord, we were also suggesting that there can be some minor variation in the sharing ratio, or, my lord, apartments could be sold, because, my lord, Meera Patankar and Yamuna Patankar are residing in America. Question of their coming and occupying any property here is very remote. So we also suggested, my lord, they can sell the property together and, my lord, realize the proceeds and divide it in some amicable manner. All these things, my lord, we had initiated. But then, my lord, due to change of counsel, my lord, we could not take it forward. The executor is an elderly chartered accountant, my lord, Mr. Armugam. So, my lord, he had also made efforts.
Let us see.
Yes, my lord, very well, my lord. I am grateful, my lord.
Number 4.
But serial number 4, my lords.
Yes.
Notes appear for the petitioner notes. Could
Yes.
it be, Lord, notes seniors preferring a physical arguments itself, notes, not setbacks and Bangalore notes.
We can't hear you.
Notes, senior notes is preferring for physical arguments itself, notes. If lordships notes resumes sitting back in Bangalore, first week of March, lordship will give it.
No, now unnecessarily.
Yes.
We are prolonging this matter.
No, my lords. No, my lords. That.
Have you filed written submissions?
Lords, no, my lords. Written submissions are not filed.
File written submissions.
Please.
Lord counsel appearing on behalf of the petitioner, appearing through VC submits that they would prefer appearing and advancing arguments in physical mode. Both sides to file written submissions. There is no representation on behalf of the respondent when the matter is called out.
Interim order may be kindly.
Interim
Last
order
date it was not extended.
Interim order is earlier granted is extended till the next date. This is the matter in the week commencing from 10th of March.
Please, my lords.
My lords, I apologize, my lord. Serial number 1, I appear for the petitioner, my lords.
So we have appointed a separate mediator. Same
Please, my
order
lord.
will stay. Same order will stay. However, we have appointed a separate mediator because the arbitrator expressed that they cannot be a same mediator and arbitrator.
Please, my lords.
One humble submission. One. Pertaining to Kalaburagi. First matter, my lords, it has turned infructuous. Serial number 1, my lords. I am proxy for Rajesh Dadmani, sir. Very suit itself has been disposed of before the trial court, my lords, as settled out of court.
Counsel to the petitioner submits that the suit itself has been dismissed as settled out of court. In light of the same, relief sought for in the present petition does not survive for consideration
Right.
and is disposed of as having become infructuous. Yes. Your matter is adjourned. He adjourned it. Morning, he took time.
Interim order 23 and
Interim order with there will stand extended. ಅದು ಯಾವತ್ತು ಹೋಯ್ತು? absolutely.